Hi, my name is Nick Gasca, and I'm also an attorney with Tanana Cheese Conference. I'm not an expert on China Rules 24 or 25, and I'm just an attorney who tries to slog along these rules just as you guys do when you're trying to register register a tribal court order under these rules. I also want to recognize Keith Rubin, a paralegal in our department, who actually does the groundwork with the tribes and plays an important. Oh. Do I have to repeat all that? Yes. So I've been tasked with the fast-paced duty of talking about court rules. So if any of you guys have dealt with court rules before, hold on and unbuckle your seatbelt because we're going to slow down a little bit. So for those of you who don't know, China stands for Child in Need of Aid. And in 2011, the Alaska Supreme Court ruled in the case of State of Alaska versus Native Village of Tanana that tribal court orders are entitled to full faith and credit to the same extent as other states and foreign orders. So prior to the adoption of China Rule 24 and 25, there was no mechanism or court rule that would allow tribal court orders to be registered with the state for enforcement. China Rule 24 addresses the registration, confirmation, and enforcement of child custody orders, and China Rule 25 addresses how to request expedited enforcement of tribal custody orders as well. So one of the main things you may be asking is, why do you need to register a tribal court order at all? Usually an entity will recognize, you want to register usually when an entity will not recognize a tribal court order and the non-parental custodian needs that for some reason for the child. So for example, medical treatment or health-related purposes, application for benefits, applying for the PFD, healthcare. So those are the few reasons where sometimes one of those agencies or entities will not recognize a state court or tribal court order. It's also important to register it ahead of time, just so if you do need it, you don't have to worry about going through the process of getting it registered on an emergency basis. You have it in your hand, you take the tribal court order in, and they say, oh, we don't recognize that. Well, guess what? I have it registered, so maybe you will now. So what does China Rule 24 applies to? It applies to orders issued by the tribal court that when the tribal court exercises jurisdiction in ICWA-related hearings. So that's tribal care, that's foster care placement, that's adoption hearings, that's termination of parental rights. What's not covered are adoption decrees and cases heard in tribal court that resemble ordinary custody cases. So any Indian tribe or any person may register a tribal court order. And in order to start the process, you need to file a petition with the Superior Court. Now there's two ways to do this. You can file a letter, motion, memorandum, petition on your own that states the things that are required in the rule, or you can use a court form. Recently the court form's been developed so you can fill in the blank. That might be the best way to go right now, just so you're sure that you're not missing any requirements that you overlooked or you don't know what you're talking about. Also, some of the information might be duplicative. Like they might request the information of the parent whose rights haven't been terminated, as well as information for the non-custodian guardian or the person you wish to take custody from. Those things are repetitive, but again, that's why it's best to use a court form so you won't get confused. You're also going to need a copy of 2 of the tribal court orders, and you're going to need a notarized statement that the court order has not been canceled, postponed, changed, and that whether another order or involving the same children has been registered in Alaska or elsewhere. So again, it's all in a form provided by the court. You're also going to need provide the contact information for the issuing tribal court, the child's tribe, the person seeking registration, the parent or person acting as a guardian or a parent right now. And you're also going to need information about other parties, such as the person who has physical custody, if different, the person who the custody was taken from, and the parents whose rights have not been terminated. So again, some of these stuff may be duplicative. And you're also going to have to state whether you want to, if you're going to request expedited or non-expedited enforcement. One of the key features of this, of providing all this information, is that there could be a dangerous situation where you don't want to disclose the information or the contact information of where the child's at, or where the proposed custodian will be. So in that case, you can ask for a limited disclosure. So there's a form for this as well, but basically the limited disclosure, you have to submit an affidavit or a certified petition that states why limited disclosure is necessary. The court will hear it and make a decision on whether or not that should be granted or not. So what do you do with these documents once you're completed? You file them with the state court. The state court will process them, and they'll issue a note. They'll send a notice to all the parties listed in your petition. And the notice will state that the registered order is enforceable as of the date of registration. It'll state that it'll state to the parties that if they wish to contest this, then they'll have to send written notice to the court within 20 days of service. And then it also states that failure to contest it will waive future right to contest the court order. So again, how do you request? Am I right? So how do you request how do you contest the tribal court order? Well, first you have to give notice to the court that you're going to contest it within 20 days of service, and you have to establish one of three things. The first thing is the tribe did not have jurisdiction over the parties or the child custody proceeding. And the most common example we see is a child's not a tribal member. Or you have to show that the tribal court order has been vacated, stayed, or modified by another court with jurisdiction. Or you have to show that the contestant was not given an opportunity to speak, or was not given notice to speak at the tribal court hearing. So once it's registered and a contest has been issued or not, the Superior Court will either confirm the order one of two ways. First, if there was no contest, it'll wait the 20 days and make sure the petition contains all the elements that were required in the petition. If it was contested, the court will make sure that the court will deny the contest if the petition did not meet the requirements, and if the contestant did not meet his burden in showing one of the three things we just talked about. And after a child support order has been confirmed by the Superior Court, it can't be challenged anymore after that. And once it's been confirmed, it can be enforced by the state. So this has happened in one of our tribes, and what we did is we went back in and asked for a writ of assistance we asked for a writ of assistance, and we showed that the order has been registered and confirmed, and the court was able to grant us the relief that we wanted, and the court should be able to grant other relief as well. So now I'm going to get into China Rule 25, and this deals with expedited enforcement of tribal court orders and requests for writs of assistance. So a word of caution is this rule applies to two specific situations. So read the rule carefully and know what you're asking before you file your document, so you're not having to repeat your request or have the court turn it back to you and say file it right, which could waste time in a situation like this. So how are requests for expedited enforcement and writs of assistance made? The same way that you file for the initial registration. You would file a petition, or you would file a verified petition with the following facts. the court's jurisdictional basis, identify the tribal or state court proceeding that could affect this proceeding, if there is one, and give the physical address of the child and the persons who having physical custody of the child, if known. Also, there's a form for this as well. So if you don't want to look at the rule and follow your own petition, you can also look at the rule or look at the court forms and fill this out as well. These are some additional requirements that are also required for filing for expedited enforcement. On a side note, these slides will be going up on the website as well, so I apologize if I'm going too fast. So please note that there are special, I said rules, but circumstances for which writ of assistance can be granted. So these rules are, they'll be requested only, they can be requested in this rule only if the child is in danger of being removed or has been removed. So if the tribe wants to remove a child from a situation, China Rule 25 would not be the appropriate way to go. You'd have to file, you would have to ask for assistance or enforcement underneath another rule. Under this rule, the court can conduct an ex parte hearing, a one-party hearing, for further fact-finding regarding the case. In the case that we did regarding this, the court did that and determined that because our tribe was trying to remove a child versus preventing removal, that we had to go another route. And if the court finds that the child is in danger of being removed or has been removed, it can order an immediate writ of assistance and request the child return back immediately. So on the expedited motion for enforcement, the court will provide service on all parties. The hearing will be held the next judicial day or soon after, and the court will order immediate return of the child unless the respondent, the person who we're looking to take custody from, can show one of two things. In the first situation, if the order has not been registered and confirmed, the person contesting the order has to show that the tribe doesn't have jurisdiction over the matter, or the tribal custody order had again been vacated, stayed, or modified by another court with jurisdiction, and the respondent was not given adequate time for notice, or if notice was given in the China proceeding, the ICWA tribal court proceeding, he wasn't given an opportunity to be heard. And the second way, if the order has been confirmed and registered by the court, and you're asking for expedited enforcement, the person contesting it can fight that by showing that the order has been confirmed and registered, but it's been modified, vacated, or stayed. So a few tips on registering tribal court orders under custody orders under China Rule 24 and 25 is to recognize that all situations aren't the same. So remember that what happens in one case may not happen in yours. And the second tip is they're relatively new to both attorneys and to judges and to the court system. So be patient and make sure that you review your paperwork so it doesn't come back to you and you're questioned and you have to start all over again, which can take more time in this process. And if you have any questions, TCC tribes have any questions about how to do this, Keith and myself, Natasha, and the rest of the legal team are available to help. And if you're a tribe not in the TCC region and you just want to talk to us and get to know our experience and ask for any tips, please feel free to call us as well. And our tips or our contact information is up here for you. And if not, I'll be around the rest of the day and you can talk to me as well. Thank you.